Okay, ABC LLC is the owner, Centermac Realty Inc. is the broker, and the property address is 330 Bryan Street, number 8, Palo Alto, California 94301. And then the beginning date is November 21st. You can just adjust this accordingly. And property management, let's say we're managing it for 1 year. And it expires on the 20th. So that's a 1 year property management agreement. Okay. And if you like, you can select that option. Sometimes, the landlord and the property management doesn't get along. Maybe either side desires to terminate early. So if that's the case, then 30-day notice is appropriate. So you check this box here. Okay. And display the rent lease sign for rent or lease sign. That's standard. Initiate, sign, renew, modify, or cancel rental agreements and leases for the property. Now, this one is talking about authority and powers. What power and authority does a property manager have? The property manager would have the power to advertise and also have the power to initiate, sign, renew, modify, or cancel rental agreement for the property. Now, if a property manager has the power to sign a rental agreement, then should the rental agreement be signed by the tenant, by the property manager, in the property manager's name or in the landlord's name? What are the pros and cons of having the property manager sign the property management, not property management, but sign the lease agreement with the tenant? Thus, legally speaking, does the property manager have the standing to sign a lease agreement with the tenant? Yes, it does. You do not have to have legal title to the property to sign a lease agreement if you have been empowered by the landlord to enter into a lease agreement with the tenant. Now, what are the pros and cons? The pro is that if there is ever an eviction, it makes it a lot easier for the property manager to do the eviction as a landlord's representative. If you have a property management agreement that is signed by the property manager, if you have a lease agreement, I apologize. If you have a lease agreement that is signed by the property manager and the tenant, then if the tenant breaches the lease agreement, and if an eviction is necessary, a property manager may commence an eviction as a plaintiff. You do not need to have the landlord to be the plaintiff. So an eviction can be conducted in the name of the property manager, even if the property manager does not have title to the property. That is the significant thing. Why is it important for the property manager to have the power to commence an eviction? What if the client lived in China and then the trial has been scheduled for the eviction, and you have the plaintiff who is the landlord? Now, if you do eviction in the landlord's name, I shouldn't have turned on my cell phone. I apologize. I was just trying to check on something. Okay, let me just kind of. All right, we're back. Okay, if you have the eviction filed in the property manager's name, the property manager can answer all questions regarding the tenancy. The property manager can sign discovery responses. Sometimes the the tenant's lawyer may serve discovery on the plaintiff, and then if you have a landlord who is a plaintiff but he lives in China who doesn't know a thing about what's going on with the lease, it's quite inconvenient, and then plus sometimes a landlord may be required to attend trial and things like that. So it's always better to have the property manager sign the lease agreement on behalf of the landlord, as opposed to the landlord signing the lease agreement. Legally, you don't need to have the landlord sign that. So it's always good that D is there. Paragraph D apparently gives the authority to the property manager to enter into lease agreement and to collect rent and security deposit. Okay, and it says here any lease or rental agreement executed by property manager for owner shall not exceed. Now this one, it kind of set the boundaries, the limitation of the property manager's power to enter into a long lease. For example, if it says month to month, then it is month to month. Now, if here you want the property manager to have the authority to rent for up to 2 years in the lease, then you type in 2 years here, and then the rent amount, you can either select market rent or minimum rent, okay, per month. That's really up to you and the landlord. But if you can have a discussion. Now, what if you leave it blank? If you leave it blank, then does it mean that now you don't have any authority to decide the amount? Not necessarily. But if you leave it blank, then it's subject to argument. So you have to kind of decide how much authority to give the property manager to rent it at market rent. Usually market rent is pretty safe, unless the landlord himself wanted to lease it quickly and decide that he wants a lower number as opposed to the market rent. Tenancy termination. Now this particular clause actually gives the agent the power to sign all termination notices as if you're the owner. That's what it is. And also to prosecute actions to evict tenants. So I don't see why you need to have the landlord be the plaintiff in an eviction if paragraph C already gives the property manager the power to commence eviction. I usually tell my client that lives in China, who is the landlord, next time you ever do have to sign a lease with the tenant, please make sure you have your property manager sign as the landlord as opposed to yourself, because you'll make her job a lot easier. You'll make the lawyer's job a lot easier too, because paragraph C already gives the power to the property manager. So something to keep in mind. Repair and maintenance. This one basically also, it's expected. I mean, if you want to give a property to a manager, you might as well let him have the authority to pay bills, to make improvements, to supervise repairs, all of those things, right? And of course, you want to a landlord may set a limit as to the amount of expenses that the property manager is authorized to incur for any one item. For example, you don't want the property manager to contact you like every minute, $50 repair, $100 repair. You want the property manager to have certain authority, but that has to be discussed between the property manager and the landlord. I'm just going to put $500 here. That's pretty common, okay? And next we're going to talk about reports, notices, and fines. If in fact the property manager receives some sort of citation from the city regarding certain type of violation, the property manager, under the terms of the property management contract, is required to respond to these notices on behalf of the landlord. Rather, of course, the landlord has to be notified. But as far as compliance goes, it is the property manager's responsibility. Okay? Well, actually, I can't say it's the property management's responsibility because sometimes it's the landlord that committed the violation. Then you can't blame it on. I mean, for example, sometimes you may have pre-existing conditions that is a violation that existed at the time you took over the property management. Then it would not be your responsibility. But if it's due to your own actions that result in the violation, not only do you have the authority to cure the violation, you are obligated to cure the violation because you created the condition that caused the violation. However, on the other hand, if it is the landlord that created the condition that caused the violation, you have the power, you have the authority to act on behalf of the landlord to cure the violation. But insofar as who's going to pay for it, if the landlord created it, then the landlord would have to pay for it and not the property manager. But as a property manager, your landlord would expect you to go ahead and take care of it, even if you did not create it. Okay, so I guess it behooves you to find out if there are conditions that might cause any problems in the future, such as a unpermitted garage or something like that. You could get a citation in the future, or the landlord could be sued by the tenant for things like that. Okay. Contract services, certainly the property manager would have the authority to enter into service contract on behalf of the landlord, including utilities, landscaping, roofing, and whatnot. Expense and payments, under the standard terms of the property management contract, a property manager has the authority to pay expenses and costs for the property from the owner's funds held by property manager. That's something that is built into the standard property management contract. Security deposit. The property manager is also empowered to receive security deposit from the tenant. However, you have to decide whether the deposit will be placed in the property manager's trust account or the security deposit will be given to the owner. Okay, so that has to be decided. Now, in the case of, as of now at least, all of the property management transactions that we're involved in, we place everything in our trust account. Because currently, I don't allow any of my agents to do property management. But in the future, that might change. Okay. Once I am convinced that you guys are properly trained to do property management. Now, if you never attended my training, I will not let you do any property management because you don't have the required knowledge and training, right? How can I let you do property management if you don't even know these things, right? Okay. Trust funds. Deposit all receipts collected for owner unless any sums properly deducted or disbursed in a financial institution whose deposits are insured. Now, if you decide, now any kind of trust funds, a security deposit, now actually, you know what? I should uncheck this X because we're talking about security deposit. Normally for security deposit, Centermac does not hold on to security deposit. Centermac prefers that security deposit be given to the owner ASAP. Here are the pros and cons of keeping security deposit in Centermac's trust account. Number one, you normally don't even touch the security deposit until the tenant has moved out. For that reason, why leave the security deposit in the trust account? You might as well let the landlord keep the security deposit. you have one less responsibility. Therefore, we should check given to owner on this one. Okay. Now the rest of it. Now, even though technically security deposit could be trust funds though, because security deposit belongs to who? The tenant. It doesn't belong to the landlord until there is a breach by the tenant. So at all times, security deposit is a third party's fund. You learn from salesperson class that third party's funds are trust funds. So I don't want to put a third party's trust fund into my account, especially I am in charge of the tenant's trust fund. I don't like to be in charge of tenant's trust fund. I'd rather be in charge of the landlord's trust fund, right? That's why I don't like to handle deposit trust fund, this security deposit into our trust funds. Okay. Other types of trust funds, standard, basically we leave them in the trust account. Okay, mandatory. Reserve, now that's something to be negotiated. No, why do you need a reserve? You need a reserve in your trust account because sometimes when there may be an emergency, you're not able to get a hold of the landlord. So the reserve is actually quite useful to pay for something in an emergency situation. So you can put something like, if the monthly rent is $2,000, you could perhaps ask for $2,000 to be reserved, but that's all. That should be decided between you and the landlord. Okay, I would prefer to have $2,000 as reserve if the rent is like $2,000. As far as disbursement goes, there are some standard language here. Okay, now in terms of priority, money. How is money to be disbursed from the trust account? First of all, compensation to the property manager first. After the property manager is paid, next, operating expenses, costs and disbursements payable from owner's fund held by property manager. So after that is taken care of, the next item is reserves and security deposits held by property manager. Now, security deposit actually belong to the tenant. If you don't hold on to security deposit, you don't have to worry about it. That's another reason I don't want to. Sometimes it's better to just let the landlord hold on to the security deposit. Now, reserve would have to be released before the balance to the owner. So the owner gets the balance after items 1, 2, and 3 have been paid. Owner's distribution, that's something to be discussed with you and the owner, and it can be dispersed every month. The default is actually monthly. So if you don't change anything, every month you're supposed to disperse the rent to the owner. Okay? That's something, to keep in mind of. Owner statement, the law requires quarterly, so I said quarterly. Why create more work for yourself? You're only required to provide a statement quarterly, unless the landlord insists that it be done monthly. Okay. Property managers funds, and the standard says property manager shall not advance property manager's own funds. So I think that's important to know. Key safe and lockbox, that has to be discussed with the owner. Sometimes you need to install a lockbox to make it easier for tenant to have an agent come look at the property. Other times, it's for privacy reason, the landlord does not want to have strangers in the house. So because of that, other times they may not want to allow you to do a lockbox. So that's something have to be discussed. The standard, if it's not checked, you can't use lockbox. If it's checked, then only can you use lockbox. Okay? All right. Owner's responsibilities. Owner's supposed to cooperate and give out the disclosure records. and supposed to hold property managers harmless. That's always good to protect the agent. Maintain the property in a condition fit for human habitation, sure. Pay all interest or tenant security deposit if required by law, sure. Carry and pay for premises liability insurance, no less than $1 million, sure. F, pay any late charges, penalties imposed by lenders, yes. Immediately replace any funds required if there are insufficient funds, sure. These are all the owner's responsibility. Owner's representation, we got some standard language here. That they are not aware of any foreclosure, they are not aware of any delinquent loans, they are not in bankruptcy, insolvent, they are not in litigation, all of this standard disclosure. Tax withholding, that is a disclosure thing. We don't usually pay a lot of attention to that, but certainly, if the owner is not a California resident or corporation or LLC qualified to conduct business in California, owner authorizes property manager to withhold and transmit to California franchise tax for 7% of the gross payments to owner that exceeds $1,500 received by property manager. That's probably another reason why there are many agents who don't want to handle trust funds, okay, and kind of avoid this tax withholding thing, especially when you have a customer that lives in China, non-resident, okay. That's another thing to consider. Disclosure, lead-based paint, we know about that. So, you have to specify one thing or another depending on the situation. Pool drain, any pool or spa, approved anti-entrapment drain. That's actually for the owner to decide. The default say it does have an approved anti-entrapment drain cover device or system if you have like a pool. Compensation, you put in an amount. Say for example, it's 6% of 1 month rent. In this case, it might be $120, right? $120 on $1,000. That's management. Renting or leasing, you don't have to negotiate upfront. You can say to be negotiated subsequently. To be negotiated on an as needed basis, or you can put it in here, okay, however you desire. Eviction, you want to mention that, you just say, now, there are some property manager actually wants to get paid if they ever file an eviction as a plaintiff, okay? But that's totally up to you. I know in Centermac, just as an incentive to our landlord, we do not charge. So we say no charge for agent services. Landlord pays all lawyers' fees and court costs. So in other words, you as part of your property management responsibility, you can specify whether you want to be paid extra if you do an eviction or not. In this case, we say no charge, right? The landlord pays all lawyers' fees and court costs. Preparing property for lease, and that's also negotiable. Sometimes, you might want to put in some amount. I don't know what that is. I'm just going to put some numbers here. That means that whenever there's a vacancy, do you want to negotiate an amount where you are being paid by your landlord for getting the property ready for leasing? If there is, now sometimes they call it like setup fee. Managing property during extended period of vacancy, that's all negotiable. Sometimes we say free of charge, okay? The landlord is probably thinking, well, why should I reward you for allowing such a long vacancy, right? Overhead and service fee added to the cost of all work performed by or at the direction of property manager. We usually put none, okay? But that can be negotiated too. And, certainly we don't provide any tax or accounting services. We don't provide legal advice, but certainly if you have a legal situation as a property manager, one of the advantage you have is that you can always come to me for legal advice, but we do not provide legal advice directly to the landlord, okay? Because he could have any kind of legal advice that he needs. I'm divorcing my wife, what should I do with this property, right? That has nothing to do with our property management, absolutely, right? Okay, but there's a bunch of stuff that, we are not responsible for. It's all spelled out, okay? Agency relationship, I don't need to go over that. Dispute resolution, I do not need to go over that. That's standard. You guys know that already. Attorney fee provision, that's standard, okay? These are all standard. Now, if you have any other additional terms, you can always add them here, okay? But that's something for me to teach you in the future. Today, I'm just kind of generally go through the form because we don't have a lot of time. I'm just going to go through one form at a time, okay? And I did my job, so the owner's name is here, and Centermac's name is here, so I'm all set up, okay, for e-sign, okay? So this is what a property management agreement typically looks like. There are different ways to do it. I know Jim Riley and Darby Riley have their own way of doing things in San Diego, and they have been doing. Now, it's very regional. In some parts, some landlords will agree to certain things and won't agree to other things, and then in other parts they will agree to different things and won't agree to other things. Okay, so you kind of have to understand the local culture. Okay. There are some parts where they won't allow you to charge a set of fees whenever there is a vacancy and you're looking to get a tenant to fill that vacancy. Okay, so I will save this form. In fact, I'm going to save this folder for part 3 in the future. So when we come back, we'll do more property management related forms, but today we only have time to cover one form, which is a very important form. Okay, so I'm glad I covered that. So if you attended the full session today, you have a good idea about the terms and conditions of the form, and also about Centermac's policies and procedures regarding a property management agreement. Okay, and that concludes my training today, and thank you all for coming in.